Workers' Compensation Court of Appeals is now in session. The Honorable Tom Christensen presiding.
Good morning. Please be seated. Mr. Lars, before we begin, how do you pronounce your client's last name? Beguhl? Beguhl. We were close. Close.
And if I mispronounce it, please.
Good morning. Welcome to the Minnesota Judicial Center for Oral Argument before the Minnesota Workers' Compensation Court of Appeals. Today's date is January 13th, 2025, and we have one case scheduled for oral argument. Pamela Beguhl versus Bridgeway to Independence, Inc. and Security National Insurance Company, with claims administered by Amtrust North America, our file number WC 24-6576. Today's argument is being live streamed and recorded. We would ask that when presenting your argument today, counsel, you speak loudly and clearly. The panel for today's argument are Judge Quinn to my right, Judge Carlson to my left, and again, I'm Judge Christensen. We have experienced counsel present today, and as a reminder to each counsel, you will be allowed 15 minutes to present your oral argument with the yellow light going on when 2 minutes of time remain. Please be aware that I will allow 3 minutes of uninterrupted time before I ask the panel if they have questions. At the 3-minute mark, I will interrupt your argument to ask if the panel has questions for you. I would ask that you keep track of your time and you're allowed to reserve any unused time for rebuttal. Should the allotted time to a party be extended because of questioning by the court, opposing counsel's time will be extended for the same period of time. When you step to the podium, and I would ask you to identify yourself and the party you represent. Ms. Boresh, you are the appellant in the case, so I will ask you to step up to the podium and present your argument. Thank you.
Thank you. Good morning. My name is Tracy Borash, and I represent Bridgeway to Independence and Security National Insurance Company and Amtrust in this matter, and I will be reserving time at the end for rebuttal purposes. It's my client's position that the findings and orders given by Compensation Judge Kirsten Marshall in her decision served and filed on August 13, 2024 with regard to the employee's left shoulder condition must be reversed. In her decision, Judge Marshall found that Pamela Beguhl's work injury of September 7, 2022 resulted in permanent injury to her left shoulder. She based this on 3 different things. First, the employee by all accounts was doing well before her work injury. Second, imaging of her left shoulder before the injury did not show tearing, but the MRI after the injury did. And she also accepted Dr. Freehill's opinions without explanation or addressing the foundational arguments made at hearing. I will take each of these and explain my client's position on them. First, as far as the adoption of Dr. Freehill's opinion, it was my client's position at the hearing that there was no foundation for the opinions, but Judge Marshall did not address that argument in her findings and order. Now, it must be remembered that Ms. Beguhl only saw Dr. Freehill because she did not get the opinions that she initially wanted from the first 2 orthopedic surgeons that she chose to treat with for her work injury. She started treating with Dr. Pepin, but after he released her without restrictions, she switched to Dr. Cooper. She testified, I believe, that Dr. Pepin was dismissive of her and wouldn't listen to her, presumably because she stated she needed restrictions and those were not given. She began treating with Dr. Cooper after that until she asked him to provide a causation opinion between her work injury and her left shoulder, and he told her it was difficult for him to say what was related to the work injury versus her pre-existing condition. He did indicate he was willing to talk to her attorney about the issue, but no report from Dr. Cooper was ever submitted into evidence. The employee said she stopped treating with him again because he was dismissive and he felt that she didn't listen to her, presumably because he was not willing to give her the causation opinion that she wanted. She then switched to Dr. Freehill, and it's important to know that she saw Dr. Freehill 18 days before the hearing. She only saw him on the one occasion, June 14, 2024. After an extensive conversation with the employee, as Dr. Freehill notes in his chart note from that date, he opined that the work injury caused a permanent aggravation of her pre-existing left shoulder condition. Now, what was said during that conversation? Records document that Ms. Beguhl specifically told Dr. Freehill that her left shoulder was asymptomatic at the time of the work injury. This clearly was not true, as the employee states in her brief. I can't cite the page number for you because they're not numbered, but it's
Let me
under section 2.
stop you right there. Any questions from Judge Quinn or Judge Carlson?
I do. I totally get your argument, Ms. Borash. I mean, I get it. I understand it. You mentioned at the very beginning of your remarks that Judge Marshall found a permanent aggravation. I didn't see that. I saw in her memo that she says, I adopt Dr. Freehill's opinion regarding causation. And I see in her findings, there's only one sentence and one finding, finding 66, which was the preponderance of the evidence fails to prove the employee has fully recovered from the effects of the work injury. Did I miss a finding that she said it was permanent? Where the judge found?
In her memorandum, she cites, she accepts the opinion of Dr. Freehill regarding causation of the employee's current left shoulder condition.
So
And by turn, Dr. Freehill found in his report that the work injury caused a permanent aggravation.
and even then, I know we're picking nits here, but Dr. Freehill's opinion, to the extent that it's an opinion, it's a treatment though, says she appears to have a permanent aggravation of the underlying glenohumeral arthrosis, which is part of her shoulder, with a possible propagation of her underlying rotator cuff pathology. So she doesn't even really give a rotator cuff opinion. Is it even an opinion?
Well, that was part of my argument at the hearing, was that this is not a causation opinion that the judge should adopt. And it's not even an opinion, a well-founded opinion about the nature and extent of the injury. But I think what happened is that Judge Marshall went a step beyond and said, because she believed, or she adopted Dr. Freehill's opinion on June 18th, 18 days before the hearing, that the injury was ongoing at least by that day. So the injury was ongoing at least by the date of the exam. And my client's position was that it was a temporary aggravation that resolved long before that.
Right, per Dr. Burt's opinion.
Correct.
So getting to the very end then, ultimately, we're going to issue a decision here. What is the remedy that you're seeking? Are you seeking just, let's delete that sentence from finding 66 and delete that sentence from the memorandum? Or are you seeking something more than that?
What my clients are seeking, Your Honor, is that the preponderance of the evidence fails to prove that the employee is fully recovered from the effects of a work-related left shoulder injury. We are seeking that that finding be stricken from the findings in order.
And correspondingly, to the extent that it's a finding, the last sentence of the memorandum.
Correct.
Okay. Do we need to adopt Dr. Burt, or is it just good enough to just say, look, we don't have to get there because there was another reason for the petition to discontinue to be granted anyway, which was the restrictions are basically the same?
You know, Your Honor, I think it does because it has repercussions beyond just what happened in the hearing. After the decision was rendered, the employee, and I don't know if I'm getting too far afield here, but the employee filed, I believe, a medical request seeking approval of the right or the left shoulder replacement surgery. So based upon the judge's findings that it was an ongoing injury. So I think
that was inevitable. I mean, that's clearly why your client wants to appeal this. I get that.
Yes.
Yeah.
So I think that it is something that does need to be addressed by this court because of the repercussions that can follow.
So, and sorry to
Go ahead.
interrupt. So you're saying that you would like us to adopt the opinions of Dr. Burt instead of Dr. Freehill, as opposed to just getting rid of that sentence in finding number 66?
Well, my argument today, Your Honor, is that there's no foundation for Dr. Freehill's opinion. So when you get rid of that, what do you have left? You have the employee statements that she.
Then I'm going to interrupt you. So let's again pick some nits.
Okay.
Over, arguably, the same arguments you have for Dr. Freehill's report could be applied to Dr. Burt's report. He saw her once. He didn't have any records from before the injury.
He had a few, but nothing addressing the left shoulder, correct?
Right, yeah, okay. So anything regarding the left shoulder before then. And he's relying on her history to a large extent. So to me, it seems like every argument you have for Dr. Freehill's report could also apply to Dr. Burt's report. Do you agree with that?
No, and here's why. With Dr. Burt, he opined that the work injury to the left shoulder was a temporary condition. If he had been provided with the record showing her long, extensive history beforehand, it wouldn't have changed that opinion. It would have bolstered that opinion. He was told by Ms. Beguhl that at the time of the work injury, when you read through his report, that she had symptoms at the time of the injury, but the injury aggravated them. Dr. Freehill does not have that history.
The question isn't would additional information change his mind. The question is what information, what factual foundation did he have at the time of his opinion? Would you agree with that?
It is, yes, his foundation, Dr. Burt's, for his opinion was based upon the records he had at the time and her statements in his physical exam. But I think you have to look at the underlying information that was provided to both doctors to see the difference.
So if I'm hearing you correctly, the only difference between what was provided to Dr. Freehill versus what was provided to Dr. Burt was in the history given to Dr. Burt, she admitted to having some symptoms at the time of the injury.
Right, and she specifically denied to Dr. Freehill, she specifically told him she was non-symptomatic. And as this court has held in the case of Benedict Service Systems, or Benedict versus Service Systems, it's a 36 WCD 710, and the case from 1983, this court has held that when an employee fails to give the proper history to an examining physician, then their opinions lack foundation and must be disregarded. So that is what my clients would ask for today.
And just a question on the standard of review, since we're dealing with medical foundation, would you agree that we should review it as an abuse of discretion then?
Yes, I would. I think the case law is clear that a judge is able to adopt whatever medical opinion they have as long as that medical opinion has foundation. And in our case, we argue that Dr. Freehill's opinion clearly did not have foundation because he did not have the proper history from the employee at the time of his chart note. And with that, if it's okay, I would like to reserve the remainder of my time.
Questions?
Is that fine?
That's fine.
Okay. Thank you.
Good morning, Your Honors. Rick Larson, representing the employee Pamela Beguhl. In this matter, the findings of the compensation.
Sorry, Mr. Larson,
could you?
You're gonna have to move closer to the microphone. That's for the recording purposes. We can hear you.
Okay, sorry. Again, Rick Larson representing the employee in this appeal. The findings of the compensation judge are supported by substantial evidence in the record as submitted as a whole. The judge exercised her discretion as the trier of fact to choose expert witnesses that she relied upon, and also the credibility of the employee as a witness. These are things that are unique roles to the compensation judge and should not be overturned if they're supported by the evidence. This case stems from a 2022 injury, but the employee did have some pre-existing injuries and a condition. She was injured in 2004 when her arm was grabbed. She had a surgery performed November 1st of 2005 by Dr. Mark Holm, had a good surgical result. The MRI scan that was obtained relating to that injury showed no tears in the supraspinatus, and that's significant. Also on the surgery report from Dr. Holm, he looked and couldn't find tears in the supraspinatus in that surgery. So she had a good surgical result. They sent her off to get a functional capacity, and that was performed in 2006. And since then, she's been working essentially within those restrictions, even to this date. And she returned to work without incident until 2009. She had an aggravation of that same condition, went to the doctors. They had another MRI scan obtained. That one showed no tears. That was March 1st of 2010. And she saw Dr. Beguhl at Summit Orthopedics for treatment of that injury. First time she sees Dr. Beguhl. And Dr. Beguhl treated her conservatively, gave her injections, and said, basically, you're going to have to live with it. And he last saw her in August of 2010. He said there was no surgical lesion, and so she returned back to work as she's always done, and worked until, well, she started work with the employer in 2018. And she didn't have any problems with her shoulder until 2019 when she saw Dr. Beguhl again. This is after she's working for Bridgeway. And went to Dr. Beguhl, had an increase in her symptoms. He gave her an injection, didn't need to go back again, and she continued working. That was a nine-year gap from the time she left Dr. Beguhl's treatment in 2010 until she came in and saw Dr. Beguhl. 3 years after that date of seeing Dr. Beguhl is when this accident occurred on September 7th of 2022.
Let me interrupt you right there, Mr. Larson.
Yes.
Judges have any questions? Judge Quinn, Judge Carlson?
I sure do. So Mr. Larson, I mean, kind of following up on the same questions I asked Ms. Boresh, you know, procedurally, this is before the compensation judge on the petition to discontinue. She grants it. She grants it on the concussion issue. There's no dispute here. She grants it on the shoulder injury. And again, at least regarding the reason, one reason she could grant it, which is the restrictions are basically unchanged. There's no dispute there, at least not now. It's not appeal. What's wrong with us just vacating that one sentence in the finding 66, which is what Ms. Borash's client received?
I understand where you're coming from, Your Honor, but she adopts the opinion of Dr. Freehill, and Dr. Freehill indicates that the employee has sustained a permanent aggravation, or at least apparently he believes sustained a permanent aggravation of her underlying condition, and she has not yet really recovered from that. But did he? I mean, you know, and that's the problem I have. I mean, I'm reading Freehill's note, and and I read it already out loud. She appears to have a permanent aggravation of her underlying glenohumeral arthrosis. So he doesn't say she does, appears. I don't even know if that gets us to more probably than not. Yeah.
And then possible propagation of the rotator cuff pathology. I'm fairly certain that doesn't get us to more probably than not. I'm very troubled by her adopting this rather vague opinion. Here's what's significant about this. Since this injury, the employee, all doctors agree, including Dr. Burt, that she needs a reverse total shoulder surgery. Right, no doubt. She is and her testimony is that she's in pain every day. In the past, up until the September 7, 2022 injury, she wasn't in having pain and symptoms every day. Now it's gotten to a point where it's every day and it's significant, and she needs a surgery. Yeah, and I have no doubt everything you just said is true. Okay. I have no doubt about that. Yep. But, you know, it doesn't even seem like the nature and extent of the shoulder injury and whether it is or isn't permanent was necessarily tried, given the restriction basis for the reason for granting the petition to discontinue. I mean, if we were to vacate that one sentence, but not adopt Dr. Burt's opinion for the reasons that Judge Carlson was talking about earlier, you both can try the issue. You can try the causation issue, the nature and extent, and the causation, including the need for the surgery.
I understand that. And I understand what you're saying. The restrictions are the same. The effect on workability is the same. And she doesn't have an effective wage loss. I understand what you're saying there. Yes.
So, I mean, I just am troubled by adopting this, or seeing Judge Marshall adopt this as an opinion when it's kind of wishy-washy. And it's a treatment note. I mean, you didn't seek an opinion. So
No.
I get that.
Yeah, it's a chart note.
Yeah.
And yes. And
And Mr. Larson, I just want to talk a little bit more about besides the wording of the report,
Right.
I just have a few other questions. It looks like Dr. Freehill relied on the history that your client provided to him of being asymptomatic prior to the injury. Would you agree with that?
I would agree, yes.
And would you agree that she was not, in fact, asymptomatic prior to the injury?
I think you're getting into semantics about what asymptomatic is. For her, she described it as fine, being able to manage the baseline with her permanent restrictions. So
But that explanation, right, you're right,
Yeah.
that understanding of asymptomatic is different than my non-medical understanding. And your clients would probably be a non-medical understanding as well.
Yep.
But that's what's in his report, and arguably that's what Judge Marshall was reading as well. So would you agree that if asymptomatic meant something other than fine, that Dr. Freehill then did not have the correct factual foundation for that opinion?
under that set of assumed facts, yeah. But you have to look further to see, it's really terminology for her. And doing fine means being able to work, her activities of daily living aren't affected.
But the report doesn't say she's doing fine.
I know,
The report says she's asymptomatic, and could be two very different things.
I agree.
And we don't know from reading his report what his understanding of that was.
I understand. And in that regard, talking about Dr. Freehill's, the foundation for his opinion, I think your points are well taken about Dr. Burt. All the things that they're attacking, the foundation of Dr. Freehill apply to Dr. Burt as well. And there's case law, the Feifel decision, Feifel v. Uselman, that if both doctors have adequate foundation or the same foundation, then the compensation judge's finding must be upheld. So assuming that to be the case, both could be said to have the same foundation under that set of scenarios.
And then going back to my question that asked Ms. Borash, would you agree, because we're dealing with medical foundation, that the standard of review that we will use in this case, or should use in this case, is abuse of discretion?
You'd have to do that to find, to reverse the compensation judge's finding. The employee, I'm sorry, can I proceed?
Yeah.
Okay. Following the injury, it was a violent injury, traumatic. She was assaulted from behind and pushed into an elevator. Theory of this case from the employer and insurer that this is incremental damage that has, accrued over the years. And there's absolutely no medical evidence, no documentation, no scans, no medical records, personnel records to justify that or support that. So there's absolutely no evidence to support that theory. The October 24, 2022 MRI scan in this matter showed she had a fully torn rotator cuff and that it was retracted. All the doctors now indicate that she needs a reverse total shoulder surgery. Never in her lifetime had she been told that, or since 2004 when she had that injury to the current, had she ever been told she needs a reverse total shoulder surgery. It's a significant surgery. She's basically getting by. She's able to work within the restrictions she has now because she has to. She has to work. She has to make money. Benefits were discontinued, and so she has to do that. And she's doing that right now. She needs the surgery. It's interesting, the IME with Dr. Burt. Dr. Burt was not provided previous medical records or scans. His report says she had a significant temper aggravation. He also goes on to say she had significant reduction in the range of motion and weakness. That was a present tense statement he made at his when he examined the employee on the date of the IME. And the date of the IME was 9 months after the date of injury, and that was 7 months after he claimed she should have been at MMI. So they're very significant findings. He's trying to, parse words about being insignificant. It was, and it is a significant injury.
Mr. Larson, you would agree that if you just started that sentence or that statement with Dr. Bird had no prior medical records or scans. Dr. Freehill didn't either, correct, before the injury?
Yes.
So the criticism to one expert opinion is, and I'm saying Freehill is an expert opinion, I know you didn't solicit an opinion.
Right.
But they apply equally, really.
I agree.
I am troubled by one thing relative to your criticism of Dr. Bird's opinion, and it's because of the Giannotti case. There's no foundation objection to Dr. Bird's opinion. Well, there is a foundation objection to Dr. Freehill. So, I mean, that doesn't mean we have to adopt it or that the compensation judge did either. But I mean, we do have that problem.
We objected to the offer of Dr. Bird's report.
You objected to it because he had seen her before.
Correct.
In a doctor-patient relationship relative to, I think, her knees.
Yes.
At some point, but there's no foundation objection. And so I think there's a foundation problem, but I don't see a foundation objection. So
Okay.
I don't know if there's anything we can do with that.
Okay.
But because of the Giannotti.
Okay.
I do want to go back to one thing you mentioned, though. You talked about the FIFO case. I'm not familiar with that. Do you have a citation to that, or
yes.
spelling of FIFO?
PFEIFLE, the
EIFLE.
the Uselman, USELMAN, electric. A slip opinion, June 7, 1994.
94. Okay, thank you.
The employer and insurer cite the Benedict case, and the Benedict case is distinguishable from the case at bar here. In Benedict, the employee failed to disclose that she had been assaulted by her boyfriend, didn't mention that in pretrial discovery or at the hearing. The doctor relied on that. In this case, we've got a situation where the employee has signed numerous authorizations. It was discovered in discovery. It's her medical record is an open book, essentially. The volume of medical records that you see is just that. This is clearly distinguishable from the Benedict case. Not the same at all. And again, the credibility of the employee as a witness, that's the unique role of the compensation judge. And to find otherwise, that is her role in this case.
Thank you, Mr. Larson. You're out of time at present.
Yep.
Ms. Borash.
Thank you. Just to cover some of the arguments that were made by counsel, as far as the 2022 MRI showing a tear in her shoulder, whereas other ones previously did not, there's no dispute that that is the case. That is how it is on face value. But when you look at the 2022 MRI, you will see that has grade 4 atrophy within her shoulder, which is the worst level of atrophy that you could have. She has significant retraction in the torn ligament that's inside of her shoulder. Those findings took much longer than the 5 to 6 weeks that went by between the date of the injury and when that scan happened. So to say that there's no evidence that she had these pre-existing tears or pre-existing problems with her left shoulder simply is not true.
Ms. Borash, I just want to switch over to the credibility
Yes.
argument. Just before I sat down, Mr. Larson talked about the employee's credibility, and this was something I was going to ask him before, but figured I
Okay.
could say that although there was no specific finding, at least that I can remember or see right now about the employee's credibility, you do speak a lot about her credibility in your brief. How is the employee's credibility relevant to our decision at all?
It is in terms of one of the bases upon which Judge Marshall made her determination was that the employee was fine up to the time of the work injury in terms of her left shoulder. And then after that, she was not. Well, then that assumes that you believe what her testimony was at trial. So that's where the credibility determination comes in. And as far as her credibility, notably, the judge actually found in deciding that she did not sustain a long-standing concussion injury, she actually found in her memorandum that the employee's symptoms, as she described to her medical providers, increased after the work injury, which, quote, calls into question the validity of her complaints. So she did not, you're right, make a specific finding as to the employee being credible, but in her memorandum, she acknowledges that when she was seen by her providers for the concussion injury, that her credibility is in question. And that also comes out in the 2 neuropsych tests that were performed, one by an IME, one by her own treating doctor, where she failed all the validity tests on both, to the point that the findings were could not be interpreted.
How does the credibility assessment tie into the foundation argument for Dr. Freehill's, again, I'm using air quotes, her opinion?
Right. It doesn't as far as his opinion is concerned. It does, like I said, because the judge made her finding based upon 3 different pillars. One of those pillars involved the credibility of the employee. But yes, it does not touch on Dr. Freehill's opinion itself. And quickly, the other argument that was made, I just want to acknowledge that counsel has acknowledged that Dr. Freehill does not have foundation for his opinions. And again, if your honors simply strike the sentences from her findings in order with regard to the nature and extent of the right shoulder injury, without even having to adopt Dr. Burt's opinion, then that would be an acceptable outcome, my clients believe.
Thank you, Ms. Borash. Your time is up. Thank you both, counsel, for your presentations today. Help the court, and we'll take the matter under advisement. We'll issue a decision in 90 days or within 90 days. Thank you very much.
Thank you.
All rise.
Well, I didn't go nearly as bad as I thought. Did you see my leg up here shaking the whole time?
That's for so calm. That's so amazing to watch. Oh my god. One thing is doctor before was broken. Oh, hi, I'm Greg Kirby. Hi, hey, see, Priya. Hi, it's Marie.
Oh, okay.
All right. Now there's one more of us.
Oh, okay.
You're told that she's 7. She's not really.
Oh, much better to be here. When I went out to my garage this morning, and it's super.
It was frigid. Yes.
Yeah. So I used to work with Dr. Carlson. Okay, so I'm from Broadband Carlson. So her husband Jeff. So many. But yeah. But, so I've been practicing for like ever. This is my second time doing it.
Oh,
Yeah.
wow.
Yeah, so that's why I was like, okay, can you tell me what I'm supposed to do? Like, you know, when I get here.
Are the time events?
Yes, yes.
Wow.
Well,
okay.
because I'm just like, okay, what am I supposed to do? Do I